This is case number. All right, this is case number U 22662715. This is Calvin Goodwin versus people of the city of Detroit versus Calvin Goodwin, it looks like. Your appearance for city of Detroit. For Mr. Goodman. I see Mr. Goodwin on the Zoom. Good morning to you, sir.
Good morning.
All right, is there anyone, do you have an attorney representing you, sir?
Yes, Your Honor. Good morning. I am here, Till Manager Wilkerson, P81003, on behalf of Mr. Goodwin.
All right, thank you. Good morning to you, counsel. So tell me what's going on here. I don't see that there's anyone from the city on this, but I know that this is a petition to set aside a city-based conviction, correct, sir? Correct, ma'am?
Yes, Your Honor. And we have received a response back from the Michigan State Police as well as the Attorney General. The application was sent to the city of Detroit. I'm not sure if they chose not to respond, but we don't have any objections at this time. The Attorney General has sent a letter saying that Mr. Goodwin is eligible. He does not have any new convictions, no pending convictions. This is the only trouble that he has been in that shows up on his background. And at this time, Your Honor, we're just respectfully asking the court to set this matter aside.
All right, I've reviewed the file provided in this matter, and the court has heard the information provided by counsel as an officer of the court. There is a significant amount of paperwork that has been submitted to the court that seems to verify that that defendant is eligible. And accordingly, I'm going to sign an order setting the conviction aside. It is so ordered at this time.
Thank you, Your Honor.
Thank you, counsel.
Thank you.
Your Honor, do you have a copy of the order, or does the office need to send it in to the court?
That's why I'm looking through the packet now. Just one moment. Yeah, I think I'm going to need an order from you, Counselor. You can email that if
Yes.
you will. Let me give you the email address where you send it to. That's Latifah, latifah.hunter@36districtcourt.org.
Thank you, Your Honor. I'll have it sent right over.
All right, thank you. Perfect. All right, good day to you.
Have a good day.
Hey, Mr. Good. The court now calls case number Z, strike that case number 21170686. This is American Express National Bank versus Darlene Williams. The matter is before the court, set on for a status conference. Your appearance for American Express.
Yeah, sure. Good morning, Your Honor. Attorney Jason Brainer, P69653 on behalf of American Express.
All right, thank you, counsel, and good day to you. I'm looking now for Darlene Williams or anybody representing Ms. Williams. If you're on the Zoom, please say something at this time. Ms. Williams, say something if you're on the Zoom. Yeah, unmute yourself. Push *6, please, on your device. That should unmute you. There you go. Good
Can
morning.
you hear me now? Yes, I'm here. I'm sorry.
All right, very well. It looks like I don't have a complete file this morning, but this looks like this is a complaint to recover an indebtedness rising out of the use of a card or a line of credit. I received a handwritten document from Miss Williams in response to the summons. as also a to whom it may concern letter as well. And it sounds like that, Ms. Williams, it sounds like you're not really disputing this claim, but you're asking for an opportunity to pay it at a certain monthly rate. Is that what's going on here?
Yes, that's correct.
All right, and Mr. Brainer, have you had an opportunity to speak with Ms. Williams regarding her desire to try and get this resolved in the fashion that I mentioned?
So, Your Honor, I personally have not, but I did notice in our file this morning that it looks like we have reached an agreement with Ms. Williams. Was reached on April the 13th. And so what we just like to do is maybe adjourn the status conference out for about 45 days if we could. And that should give us time to get the stipulated agreement over to Ms. Williams to review, sign, come back to us. We'll get it over to yourself, Your Honor, and then we should be able to move on.
All right, well, it certainly sounds to me, 45 days is the only part of that I have a problem with. It sounds like something that can get wrapped up in the next 14 days if you already have an agreement. And if you care to put those terms on this record, then I guess what can happen is that the document can be drawn up and emailed over to the court. I sign it, get it out to the parties if those terms are agreeable to both sides. If that's noted, and I'll sign the order consistent with the agreement. I don't want to put a long time of delay on this if the parties are ready to go forward.
Okay, sure. That would be fine with plaintiff, Your Honor.
I agree.
All right, so
Okay.
somebody ready to tell me what the terms are, and then you can email the proposed order to me.
Okay. So
Yeah.
it looks like what's going to happen here is it looks like it's going to be settled in full for $4,412.46. The first payment's going to be due, looks like it was due April the 11th. Looks like in the amount of $22.56. And then the next payment's due on April the 28th for $100. And then let's see here. 2, 3, 4, 5, 6, 11, 12.
It was for $122.56 for 36 months. And
All right.
it is due on the 28th of each month.
Yeah, that's what I have right here. Mhm.
All right, and that was to commence on the 11th. And of course, we're already past that date. So did you send in a payment already, or what's happening here?
No, what happened was I called them, and spoke with them on the 11th, and they took a partial payment and said that the other remainder of the money will be due on the 28th. That's when the payments will be due.
And that's so this, on April the 28th, you'll be paying $100 or?
Yes, that will complete the $122.56, yes.
And then every month after that will be $122.50 for the next 36 months, I believe you said, correct?
Yes, $122.56 for 36 months.
36 months.
Yes, that's correct, Your Honor.
Your understanding of the agreement as well?
That's my understanding as well, Your Honor. Yes, that's what I see right here.
All right, so ma'am, those are the terms with the entry of a judgment in this matter, a settlement agreement in this matter under those terms. Would you have any problem with that being sent over to be in the court signing off on that?
Oh, no, I won't have a problem with that.
All right, so what's going to happen is that a counsel will draw up an order and then he'll put your initials on it by consent. And that's because it's on the record. And I will sign that order and then you'll get a copy of it. If for some reason there's anything in that order that you believe should not have been put in there, then come back in on this Zoom and say, Judge, I got the order, but it's got something in there that we didn't agree to. And I'll get the other side in and we'll fix that. Otherwise, the order should say exactly what we talked about here today.
Okay, thank you.
All right, counsel, make sure you have the email address where you can send that to me. That's Latifah, LATIFAH.Hunter@3636thdistrictcourt.org.
36districtcourt.org. Okay, certainly, Your Honor. I've got it right here. And we'll get that over as soon as it's drafted up. And just to be clear, Your Honor, when you do see it come through, It's going to show 37 payments, but that's going to be because the 2256 and the $100 payment from this month are broken up into two separate payments. And then you'll see.
You understand that,
So-
Ms. Williams?
Yes, I do.
I'm sorry, Mr. Brady. Anything else, sir?
No, that's it, Your Honor.
All right, thank you to the two of you. I await the order, and I wish you well going forward in resolving this matter.
Thank you.
Thank
so
you.
much.
All right. Thank you so much, Your Honor.
Yeah.
Take care.
The court now calls case number 21, strike that 22-177500. This is iHealth Pharmacy LLC versus City of Detroit. The matter is before the court, scheduled for general hearing. Your appearance for iHealth Pharmacy, please.
Good morning, Your Honor. Jonathan Green, P 51461 on behalf of the plaintiff.
Thank you, Mr. Green. Good morning to you. For the City of Detroit, your appearance at this time.
Your Honor, I don't see that any of the defendants are here this morning. I just fired off an email to them. You know, I know both Ms. Blanca and Mr. Ashton. So it's certainly not like them. So if the court would allow it, I would just as soon ask for a scheduling order here. We've already started to engage in some discovery.
Got it.
And I'd be happy to tell them what's going on here. I already told them I wouldn't be asking for a default or anything.
Got you. So you didn't ask them to come in. And by the way, the record should reflect that I'm looking at the plaintiff's matter to address the City of Detroit and Michigan as defendant and Michigan automobile insurance placement facility as defendant number 2. That's what Mr. Green is referring to when he says defendants. I call the case, I only mentioned one. All right. So when you emailed the respective attorneys, did you see if they were going to come into the Zoom, or you basically just indicated that you'd be requesting some type of scheduling order?
What I told them, Your Honor, and I can read it here. I said there's a pretrial in 36th District Court via Zoom. I put the Zoom number there. I said I don't know if they got notice. I said I would ask for 90 days discovery and let them know what was going to happen with the court.
All right, Mr. Green. What I'm going to do is I am going to go ahead, as there are experienced attorneys in this, I'll go ahead and set up the a scheduling order. I'm going to initially start out with a 60-day discovery order, and maybe a little bit beyond that, but we'll call it a 60-day discovery order. I'm going to give you a date for return under that order. It will allow for open discovery and exchange between the parties during that period of time up to the court date. That next date is going to be June 28th, June 28, 2022, and that's going to be at 9:45 a.m. The order will also provide that the parties may file motions, either non-dispositive, dispositive, or non-dispositive motions, and set them for hearing on that date of June 28th as well, so long as they allow at least 10 days opportunity for the opposing party to respond. So either side can, if it arises that that's something they wanted to do, file a motion, dispositive or otherwise, before the court, set it for hearing on the 28th. I will hear it on that date, so long as the other side has been given at least 10 days notice before the hearing date, right? And on the next action date, that will be the close of discovery. But of course, if the parties have moved along and are getting things done and need a little more time, then the court will address that at that time. And also, if there is the need for the filing of a motion subsequent to that time, then we'll address those issues at that time as well. All right, so I'm going to send out an order today with the information that I provided, and with the next action date of June 28, 2022 at 9:45 a.m. All right, thank you, Mr. Green, and good morning to you, sir. Have a good rest of your day.
Thank you. Be well, Judge.
Thank you. The court is now calling case number 21-162-798. This is MetroMed Pain Management versus City of Detroit. The matter is before the court. I believe that there was a motion and it's adjourned regarding the motion. Your appearance for MetroMed, please. Appearance for City of Detroit. All right, we'll come back to that. The court now calls case number 21-167-456. This is Midland Funding LLC versus Danielle Brown. The matter is before the court, set on for a hearing, a status conference hearing, is the information that I have in this regard. Your appearance for Midland Funding, please.
Good morning, Your Honor. Gary Feynman, appearing on behalf of Midland Funding, P41655.
All right, thank you, Mr. Feynman. Good morning to you. Do I have on the Zoom Danielle Brown? If you're here, say something at this time.
Good morning, Your Honor. I'm here.
All right, good morning, Ms. Brown. All right, so looking at this matter, I do see the Ms. Brown filed a response to the complaint filed in this matter, and that complaint is seeking to recover under the use of a credit card or line of credit with Synchrony Bank that was had at some point. Is that correct, counsel?
That's correct, Your Honor.
So it looks like just one second here, the claim in this matter is, as set forth in the complaint, is $3,017.32. All right, so what's the issue here, Ms. Brown? Let me ask you, are you disputing that you owe this debt, man?
I'm not disputing that I owe the debt. When I called the company to try to make arrangements, the options that they had for me was not, it didn't work for my financial situation. So I didn't know what else to do but to wait for this day to come.
All right, not a problem, man. All right, so what is claimed here is that you owe approximately $3,100. How did you want to resolve it? What approach did you want to take to that?
I offered to settle, but if I could settle with some type of payment arrangement, that would be great. That at the time I spoke to someone, they agreed to the $2,000, but they agreed to have that paid up front, and I'm just not in a position to be able to do that. If there was a way I could, take that same settlement and just break that down in monthly payments, I think that would be a little bit more feasible for me to stick to.
Gotcha. All right, and counsel, I really didn't mean to disclose the possible settlements with that, but there's not really a dispute on the amounts of. Is there some room for a partial payment type situation under the reduced terms that Ms. Brown talked about? And you don't have to answer that. Let me put the two of you in a breakout room if that makes sense, to see if you can plow ahead with this.
Yeah, I'd be happy to speak to Ms. Brown. I haven't had a chance to talk to her yet.
Thank you, Mr. Brown. I'm going to send a notice to Mr. Feynman for breakout room number 1, and Ms. Brown, you're going to receive that as well. And you have a chance to talk directly to see if you can get this resolved.
Thank you, Your
Thank
Honor.
you.
All right, I'll see you in a bit. Are you good?
Yes, Judge, how are you?
Good. It's good to see you back with us after that journey last week.
It's good to be back, I tell you. That exam situation. Woo.
Yeah, it's a lot. It's a lot going on in Dodge, right?
Mm-hmm. I'm glad to be back. I'll never complain again. So how did y'all do? How did you do? Oh,
Are you talking about what are you talking about?
your trial?
Oh, it was still going.
Okay.
Yeah, we gotta finish that up, tomorrow. So, yeah, they kind of, you know, they kind of fight back and forth.
Well, who did they send? Because that was Michelle's court officer.
Oh, I don't think-
You don't know what court reporter did it?
My ear did it.
Oh, my ear.
And offensive to that. And June 28th.
Yeah, I'm getting ready to hide again.
Right. Because the other lady was in here first and then before her.
You know, you mean Michelle, because that was her officer.
Oh, really?
Yeah. Because she called me and I was like, oh, wow. I said, just let the judge know. Because, you know, I forgot that was her officer.
I thought that would, you know, I would miss that every time.
So I said they would just have to sit. I said, but I imagine he know all the court reporters, but maybe if they could put a per diem in there. So they used my ear, so that worked out.
Yeah, that was the right thing to do. They have to change that.
Yeah, yeah. She was like, I don't have a problem except us, you know, and she said, I know him very well.
I'm glad they got it all changed.
What about our other cases? What happened to 249, Runman and Associates?
I still have several cases.
Oh, okay. You just skipped over them. Okay.
I still got some other things here. Stuff.
I'll just be quiet until afterwards, but they said it's supposed to snow real bad today.
I think that's something.
That's crazy.
Jay is down here today. Right with you. Right with you, sir.
These in the basket with the mail over there.
Yes.
Thank you.
Yeah.
All right, we're back on the record regarding the Suffolk 7456. This is Midland Funding versus Danielle Brown Court. They sent the parties to the breakout room in hopes that they would have an opportunity to discuss and maybe even resolve the matter before the court. Mr. Feynman, if you will update me on the status of this.
Yes, we had a pleasant conversation, and we were not able to settle, and Ms. Brown wants to think about the offer that's currently on the table, and perhaps reach out to the attorney of record during a short discovery period in the hopes of, I just have a certain level of authority to settle, and she's not ready to settle for that amount at this time. But I think probably with some discussion between Ms. Brown and the attorney of record, we most likely we're not that far apart. So I would just ask for 90-day discovery period, if that's possible, and hopefully we can get this resolved before then.
All right, very well. So Ms. Brown, you've had some discussions and you're still working at trying to get it resolved. The next step in this process, when the case has not been resolved, is for the court to set up a period of open discovery for the parties to exchange information and for questions to be sent or documents to be requested, things along those lines. And that will be something that the parties will mutually have opportunity to explore. So I'm going to open a period of discovery for 60 days, and I'm going to set the new date for the parties to come back on June 28th, 2022. And that's going to be at 10 o'clock a.m. It's June 28th, 2022 at 10 o'clock a.m. During that period of time, it is open for discovery, and the parties also can file petitions with the court, requests that they may have in the form of what commonly called motions, can be filed and set for hearing on that same date, that is on the 28th of June. And the court will hear any motion on that date, dispositive or otherwise, so long as the other side gives 10 days notice to the opposing party. So you'll get that in writing from me. Under paragraph number 6 is going to tell you that if you have a motion, something particular that you want the court to hear, you can file something saying, I'm requesting this or requesting that, and the court will hear the motion on that date. Just have to make sure that you serve a copy of that on the other side at least 10 days before the hearing. Otherwise, the next date I'll see you will be the 28th of June at 10 o'clock a.m. You'll get something in the mail from me, a scheduling order. That's what we've been talking about this morning, the scheduling order in the mail in the next few days.
Okay, thank you.
For you.
Thank you, Your Honor.
You as well.
Thank you, Ms. Brown.
Thank you.
The court now calls case number 21-173-773. This is Credit Acceptance Corporation versus Erica King. That is before the court set on for a scheduling conference. I did receive an answer to the complaint that was filed in this matter. Just one moment, and that complaint alleges damages in the amount of $4,267.45. Since it looks like there is a pre-interest amount, a pre-suit interest amount that is not included in that $4,200. Right, your appearance for plaintiff at this time.
Judge, may it please the court, I'm attorney Richard Bruson. My bar number is 35222. And I believe I'm the attorney of record today.
All right, thank you, Mr. Wilson. Good morning to you, sir. I'm looking for Ms. King, and I don't see her on the Zoom. I've looked at the notice, and it seemed to have gone to the correct address and it has the correct Zoom number. Counsel, you have any information in that regard?
Yes, I do, Judge. May it please court. Ms. King signed a consent judgment with my office. The consent judgment was countersigned by my partner, Lynn Olivier. Ms. King signed it on her behalf, March 29, 2022. I hand filed the original signed judgment with the clerk's office last week, Your Honor. The consent judgment was in the amount of the complaint allegations of $5,348.11. There is also $75 summons filing fee, a $20 motion fee, a complaint service fee of $123.93 for total cost of $118.93. The parties agreed to a statutory $75 attorney fee with the entry of the consent judgment, and the judgment was agreed upon and countersigned by all parties for the total sum of $5,642.40. In that, or I should say on that consent judgment, there was also an agreed installment payment provision of $75 per month beginning April 19, 2022, and each month thereafter until the judgment was paid in full or otherwise settled. Judge, because judicial chambers don't have a copy of the original judgment, as it happens today, my travels take me down to the 36th District Clerk's office again to hand file in about 2 hours. I will again file the copy of the consent judgment, and I'm sure between those two filings, it will make chambers and then have the judgment entered and close the case.
You won't have to do that last part because in looking through the file, I do in fact have
all right
signed proposed consent. And as you were speaking, I went over a review of the details, and they are exactly as you stated on the record. Therefore, I've signed the judgment, and it is entered at this time and will be sent out today, sir.
Well, thank you, Judge.
Thank you, sir.
All right, happy Easter. Bye-bye.
Good week to you. So I did call for Metro Med versus City of Detroit. And that looks like adjourned. Ours to file motions, and nobody has appeared. We'll just reset this one and give it a date about 30 days ahead, so.
Mhm.
this one. All right.